give you the strategies and the tactics for how to handle a plaintiff's case. George and Chris have prepared the top 10 commandments for building the successful plaintiff's case. I know it's their intention to take as many questions as possible. They're used to being interrupted on a regular basis. That's what usually happens when they're in court in arbitration. So I'm sure they'll enjoy taking your questions. George, how are you guys set up? You're going to make some opening statements?
I'm happy to jump right in.
You're going to jump right in?
Yes.
All right, just keep Chris in line.
Now, just on the heels of what Barry was saying, we are going to invite questions as we go today, but I don't know about Chris, but for me in particular, I'll answer any question that you've got, as long as it's not a trick question or a legal question. But any other question you've got, I'm happy to address for you today. We're here to talk about building the successful plaintiff's case, and when we started to address what the topic might look like and what people might be interested in, we thought that we'd start with just a simple definition of what we believe most plaintiffs are interested in at the end of the day in terms of dealing with wrongful dismissal and employment law matters. And for those that do take on cases on the plaintiff side, no big surprise here. Most of the people that we see are very distraught. Their emotions filled the full range of possible emotions out there. And you're often dealing with people who are in a very difficult time of their life relative to decisions that they need to make in light of how situations have transpired. When we sat down and looked at things, we came up with what we believe to be a measure of success for most plaintiffs, and that is to obtain the most money for the least cost and in the shortest period of time. And if you wrap all that together, it's really about time and money. That's the usual focus for plaintiffs, and something near and dear to most lawyers' hearts as well. A sense of vindication and closure, we think, are often related objectives, but not necessarily independent objectives. If we start with that as our definition of success for most plaintiffs, what we propose to do with you today is to take you through some legal considerations that impact on that definition of success, or at least potentially impact on that definition. And once we've gone through the legal considerations, we also want to deal a little bit with some of the practical considerations that also impact on that definition of success. We've got 6 areas that we've identified in terms of legal considerations. Certainly it's not an exhaustive list, but we thought it was a representative list of the kinds of concerns and considerations that Plaintiffs' Counsel looks at. We'll be taking you through considerations relating to who to sue, issue estoppel, class actions, summary judgment, due process, and disability issues in the context of a Supreme Court of Canada case known as Sylvester. So we're going to take you through those legal considerations as representative, and then we'll deal with the practical considerations. Now, I'm going to kick off first with the question of who to sue and how that may impact on the definition of success. And this age-old question really comes up in 2 contexts. The first one is which corporate defendants or institutional defendants should be named in a suit. And the second is whether or not it's at all appropriate to name individual defendants in addition to corporate or institutional defendants. With respect to naming corporate defendants, Plaintiffs' Counsel must take care to review several factors, including the nature of the duties performed by the employee, the reporting structure, both as per an organization chart and what the reality might be, the nature of the dealings between related corporations, and the compensation and benefits due to the employee and the existence of any specific agreements or company policies in that regard. And after undertaking such a review at an initial stage, plaintiff's counsel must then decide who's appropriate in terms of naming corporate defendants. Is it going to be both, for example, a parent and subsidiary company located in Canada? Is it going to be a subsidiary company located in Canada and a parent company in the U.S. or elsewhere, or vice versa? Is it going to be two or more related companies within a specific corporate group? Those are just examples of the kinds of options that you've got to direct your mind to at an early stage. Of course, there has to be a proper basis for naming more than one corporation or one institutional organization. But I think in this global economy, appropriate examples are not really hard to find. Consider, for example, the general manager or president of a Canadian subsidiary who reports to and takes direction from the CEO of a Canadian parent company. You probably have a proper basis for joining both companies in the action. Consider a sales manager working for a Canadian company who reports to the vice president of sales of a German parent company. Consider an example of a chief financial officer who oversees the finance and accounting functions for 3 companies in a group and who reports to the general manager of each company. These are all examples of the kinds of situations that can easily arise that'll lead you to considering this issue. Naming the right corporate defendants may influence a plaintiff's ultimate success or settlement prospects in many different ways. Consider, for example, these circumstances where, for example, one corporate defendant, if you've named at least 2 of them, one corporate defendant goes into bankruptcy or receivership along the way during the litigation. You obviously then have another party you can look to in terms of a pocket to access at the end of the day. Consider a situation where one corporate defendant may be public and the other one isn't, and the litigation raises sensitive reporting issues with respect to the public company's financial statements. Consider, for example, where 2 or more corporations under a corporate umbrella can share the costs of a settlement. That tends to increase the likelihood of settlement for the plaintiff at the end of the day. In my experience, careful strategy in naming both corporate defendants and individual defendants increases the prospects not only for settlement at an early stage, but maximizes the damages recoverable either before or after trial. Now, the question of whether or not to name individual defendants is usually a much more difficult question, and it does depend largely on the facts of the case and whether or not they give rise to a separate cause of action. In considering whether or not to, in considering who to sue, careful consideration certainly needs to be given to the rules of civil procedure. Certainly Rule 5 comes into play with respect to the circumstances where 2 or more claims and parties can be joined. And the general proposition is that under Rule 5, there can be a joinder of defendants where any claims asserted against them arise out of the same transaction or occurrence, where there's a common question of fact or law in the proceeding, where there's doubt as to who owes relief to the plaintiff, and where 1 or more persons may be liable for damages suffered by a plaintiff. Another consideration is also where it appears that joining defendants in the same proceeding may promote the convenient administration of justice. These are all considerations under Rule 5 that need to be considered when you're making these decisions. Section 138 of the Courts of Justice Act should be kept in mind as well. It discourages a multiplicity of proceedings. Rule 21 under the rules is another one you might want to look at, which deals with determination of issues before trial and striking out pleadings on the grounds that it discloses no reasonable cause of action. In a pure wrongful dismissal case, the ordinary type of case, you're usually only going to have one defendant, and that's the corporate or institutional employer. That's the straightforward case. And we all know that the general proposition is out there, and it's certainly been enunciated by the courts, that where we have individual employees, they're generally not liable for the wrongful dismissal of another employee because they're not that employee's employer. The question of individual liability is a significant one. One of the cases we mentioned in our materials is a case called Noseworthy. And in that case, the plaintiff was dismissed from his position with a car dealership for allowing the company's bookkeeper to sign checks in the name of another person, also employed by the same employer. The evidence disclosed that on the day of termination, the plaintiff was asked to attend at the employer's residence under the pretext of discussing the company's financial reports. And at that time, both the owner of the dealership and its sales manager accused the plaintiff of forging the signature of this other employee. And they subsequently advised the plaintiff that unless he signed a prepared letter of resignation, he'd be charged with forgery. So these individuals were threatening this employee with criminal action if they did not succumb to their wishes in terms of how they wanted the situation handled. When it came time to consider claims against individuals in that case, there were claims both for mental distress and punitive damages against individual defendants in that case. The court ultimately concluded that the plaintiff was treated in a high-handed, repulsive manner, unacceptable by any standard of decency. And on that basis, tying that together with the fact that the plaintiff had suffered symptoms of traumatic stress disorder, the court ultimately concluded that damages for mental distress were available against the individual defendants in that case, and punitive damages were also available against the individuals and the employer in that case on a joint and several basis. When you look at this area relative to individuals, you may want to consider other contexts in which the issue comes up, and that includes questions relating to inducing a breach of the plaintiff's contract of employment, intentional infliction of mental suffering, malicious prosecution, negligent or fraudulent misrepresentation, defamation, assault. There's a number of areas that potentially can come into play when you're looking at whether or not to bring in individual defendants. The final point I leave you with in this area is just the question of costs. When you're acting for a plaintiff, obviously you have to be very careful. It's easy to name extra corporations and extra individuals, but at the end of the day, if you didn't have a proper basis for doing so, and particularly where these extra defendants retain their own counsel, there obviously can be significant cost consequences. So a very important practical consideration to keep in mind. So those are my brief comments on the question of who to sue. My esteemed colleague, Mr. Chenoweth, I think would like to say a few words about issue estoppel.
Issue estoppel is the concept whereby you're going to prevent somebody from relitigating an issue which had been decided in a previous proceeding. It's like coming back from the grave. Courts are obviously going to take a look at that because, as we all know in labor law and other law, court time is valuable. So it is a very important consideration to look at right away if there are other proceedings which in any way relate to the action that you're currently considering on behalf of your client. The leading case, I'm sure you know, is Rasnan. And the test that Madam Justice Arbella set out to look at that concept was threefold, basically. Was the same question of fact at issue had it been decided previously? Was the prior decision judicial and final? And are the same parties involved in both proceedings? George's discussion earlier, if you have added other parties on in the civil section, you're going to defeat Rasnan right off the top. So the parties have to be the same. This is popular nowadays because we have, as you know, a plethora of legal institutions that can, in essence, slightly re-examine or relitigate these issues. You've got your Employment Standards Tribunal. You can make a complaint under human rights. You can bring a civil suit for wrongful dismissal. And you can also, as plaintiff's counsel discussed with their clients, be applying for UIC or EI benefits, which also involve a hearing and a question of entitlement. So in any cases, for example, of cause, you could be having 4 or 5 different discussions of cause in those different forums, and they have implications to each other, and in particular to issue estoppel itself. So when you're acting as plaintiff's counsel, you have to take these different legal houses into mind, and you have to basically advise your client, if you're going, for example, to apply for EI benefits, what you write down and what you say and do there could come back in another setting to help you or haunt you. You have to keep that in mind. And issue estoppel can be brought into play by either defense or plaintiff's counsel, depending on what the exact issue is. Granted, usually defense counsel. The unfortunate thing about issue estoppel is that there isn't, let's say, a consistent context to rely on. And then in the paper, you know, if you look at Razin, and Razin attempted to make the decision of issue estoppel clear. Unfortunately, some of the decisions that have come out since have muddied the waters. The case of Hainan and Frito-Lay is cited in the paper. The Court of Appeal in Ontario had ruled that an employee could pursue wrongful dismissal action even though the employment standards claim for termination pay was dismissed. And then the fact of the case is set out in the paper. Basically, the Court of Appeal said that where there's a question of cause for dismissal, it does not involve the same issue as whether an employment contract had been impossible to perform under the Employment Standards Act. This differentiation in legal issues is paramount. I can tell you a rather personal, embarrassing story. I went and did a Razin motion, and thinking that this was in the hat, I couldn't miss. Had success at employment standards, cause was alleged. I went to do my Razin motion before the court. I lost. Counsel had very skillfully, in its civil pleadings, in the defense, added new legal issues to the interpretation of the employment contract, and the court allowed itself to find that the issues, therefore, were not the same. They could distinguish the two, and I had to proceed on to trial. And of course, you know, one of the issues you have to consider when you act for a plaintiff is, as George pointed out earlier, costs. If you're going to recommend to a plaintiff that they consider the aspect of issue estoppel, you also have to advise them that there's, looking at the case law, and in particular in this area because it's divided, there's a chance for failure. And as you know as counsel, if you aren't successful in that motion on issue estoppel, you're going to have to basically start a full proceeding, and the costs that you've incurred in that issue estoppel discussion are basically lost. So it's an important issue. It's a divided house. There's a discussion in Minot at the end of the paper where the court ruled that a plaintiff could file a wrongful dismissal action despite the opposite ruling of a board of referees under the Unemployment Insurance Act. EI was denied, but the plaintiff could still in Minot bring a wrongful dismissal action. Again, you would think that issue estoppel would make that easy. It didn't. Finally, there's the case of Schwennicke versus Ontario that's listed, where the court felt that a decision by an umpire in an employment insurance claim that found that the plaintiff or the claimant was guilty of misconduct. The court in this case found that the umpire had made findings of fact on the issue in question, and therefore he was barred on bringing a civil action for constructive dismissal. These two cases go exactly in the opposite direction. So the only word of advice I guess I could apply is from my own experience, you have to talk to your clients about these things. I'm sure your plaintiff clients are going to have a hard time even understanding what the word issue estoppel even means, but if you get through that, the law is not clear enough that it may be of help to you, but nonetheless you have to have that conversation as a jumping off point once you finish George's aspect of who to sue. It's probably the next thing you want to ask yourself. Have you applied for your unemployment insurance? Have you gone to human rights on your own? What have you done on your own? What bodies have you canvassed, or have you canvassed any at all? And you need to have that discussion before you proceed along in the avenue that you've chosen for your legal proceeding.
Actually, this matter is about to be disposed of because I argued the issue of issue estoppel before the Supreme Court of Canada 2 weeks ago in the Daniluk and Ainsworth case. And it was a full hearing just on these conflicting decisions.
So when that decision comes out, you get it hot off the press, it'll solve your problems. Thank you.
I'm going to get into a bit of a review now of class actions. And if we go back to our original definition of success for a plaintiff, one of the common objectives for plaintiffs is to look to the least cost in terms of securing what the plaintiff views as a just result. And we've been hearing over the years, time and time again, about how contingency fees are coming to Ontario, and they're still coming. They haven't arrived yet. And the exception to that rule, though, is with respect to class actions. We've now seen the beginnings of class actions in employment situations, and in my view, the fun has just begun. One of the key elements is this question of being able to structure the legal fees with counsel on a contingency basis, where, as you know, on a contingency basis, no fees are payable if there is no successful conclusion to the litigation. Now, there's a couple of cases I want to touch on to highlight this area. The first one is the Gagne and Silcorp case, and that's a 1998 decision of the Ontario Court of Appeal. And that case actually arose in the context of the lawyers coming to court to increase their base fee. And what you can do under class action proceedings as counsel is bring an application to the court to get more than your hourly rate multiplied by the number of hours that you've put in. In this particular case, the counsel for the plaintiffs in the class action was seeking endorsement by the court of his proposal that the multiplier be a multiplier of 3. In other words, 3 times what he would normally charge for the services that he provided. So that's how the case got into the court. It went on a motion before a motions judge initially, went up to the Court of Appeal. And what had happened was that the action was concluded successfully, and it was now time to determine what costs were appropriate. By way of background, this was a situation where Silcorp had both Becker stores and Max Milk stores, and they were looking to merge those stores, and as a result, I think there were 65 employees that got involved in the litigation who lost their jobs as a result of this merger. And as it turns out, Silcorp initially offered these employees not even the minimum amount under the Employment Standards Act. And consequently, a class action was commenced. Gagne was put forward as the representative plaintiff. And upon the bringing of the motion, there was a motion brought to court seeking an injunction attempting to compel Silcorp to comply with the minimum provisions of the Employment Standards Act. Ultimately, as a result of that proceeding, Silcorp agreed to do that. They provided an undertaking to do so. And the parties then entered into intensive negotiations, which culminated in minutes of settlement. And it's those minutes of settlement which were ultimately reviewed by the court in assessing what costs were appropriate for the lawyers involved. It was a very complex settlement agreement, but it included various features such as there were claims for punitive and exemplary damages, and as a result of the settlement, those claims were not pursued. There was a reference directed under the Class Proceedings Act to determine the quantum of damages for each individual plaintiff, or each member of the class at least. And the terms of the reference included both a mini hearing process with a mediation stage and an arbitration stage. It also provided that the class members were allowed to be represented in the mini hearing process by a personal lawyer rather than the lawyer acting for the entire class. So as a result of the negotiations that ensued in the minutes of settlement, there was successful resolution of the claim. 65 class members ultimately recovered something slightly less than $2 million as a result of the proceedings. In considering what was appropriate by way of cost for the solicitors involved, the court then looked at the Class Proceedings Act, which itself defines, to some extent, what constitutes success in a class proceeding. And this is a bit vague in the legislation, but under the Class Proceedings Act, success in a class proceeding includes judgment on common issues in favor of some or all class members and a settlement that benefits one or more class members. And with that as background, the court then went into looking at what degree of success was actually achieved by the lawyers on behalf of the class. And in that regard, the court looked at the following factors. That there was partial success in extracting a commitment from Silcorp to comply right away with the Employment Standards Act. The ultimate settlement of the common issues was achieved quickly. The settlement provided for a creative and effective mini-hearing process that resulted in the complete resolution of all individual claims within little more than a one-year time frame. And all of those factors were considered to be relevant with respect to the degree of success, which in turn influenced the court in deciding how much the lawyers should recover in the process. The long and the short of this case was, instead of giving the lawyers 3 times their base fee that they'd asked for, the court concluded that a multiple of 2 was appropriate, and that's what they did award. Now, briefly, the second case that I should bring your attention to is the Webb and Kmart case. And that involved a situation where Hudson's Bay took over Kmart. It closed 31 stores across Canada, and it displaced 3,000 to 4,000 employees across the country. And what the fight was all about was not about employment standards. The company in this case gave not only the employment standards entitlements, but went further. The fight was about whether or not the company had granted to these employees enough compensation in lieu of notice. So in other words, it was the typical debate about what's the right number relative to reasonable notice. This is a 1999 case that, in which the judge gave us some interesting comments about the practicality of conducting litigation as an individual and potential success as an individual. And the court made the following observations in delivering its judgment on certification of the class in this case. The court said it's now become common knowledge and the subject of adverse comment that the costs of civil proceedings before our court have gotten out of the reach of the ordinary citizen. Illustrative of this point is a report that I saw recently indicating that the average civil trial in Toronto lasted 3 days at a cost to the plaintiff of $37,500. Well, I hope that none of the individual claims here would involve that amount of court time or that kind of expenditure. I could easily imagine a former part-time sales clerk being deterred from doing anything if quoted a potential legal cost of 1/100th the above amount. In other words, what this judge was saying in the circumstances of this case is if you quoted a lower level administrative type employee anything more than nominal amounts to get the case to court, generally speaking, they're not going to proceed with litigation. Many people can't afford it. What the Gagné case and Webb case illustrate for us at the end of the day is that there are avenues to ensure success for plaintiffs relative to costs. I think that we're going to see many more Webb and Kmart type situations where there are mass terminations of employment. And I think we're going to see many more class actions coming to the courts where the simple issue is what's the right number at the end of the day. This case, I think, is a warning bell for employers, especially large corporate employers who may have to undergo these significant levels of dismissals within their organizations. Chris, I'm going to ask you, if you would, at this point, to maybe deal a bit with summary judgment and how that plays into success for plaintiffs.
Summary judgment is also, like issue estoppel, in my estimation in any event, a bit convoluted. I don't think the law has decided that, and I don't know if Howard's got a case at the Supreme Court on this one or not, but this is another area that cries for clarity, in my opinion. Summary judgment obviously is attractive to plaintiffs because it's a quick way to try and get a decision from the court. You bring a motion under Rule 20, and it's delivered, the motion's made after your pleadings are exchanged. So obviously, when you are drafting your pleadings, if you think you have that opportunity, then it's paramount how you draft your pleadings. What you're trying to establish is that there's no genuine issue for trial. If you have cause allegations going back and forth, you aren't bringing a motion for summary judgment, in my humble opinion. So the statement of claim that you proceed to draft might be, for instance, that the only contentious issue that you're hoping the court will have to deal with is notice. Whatever formula you think exists, or however you want to plead that. If you can draft such a pleading, and if the defense counsel responds in kind, not raising other issues in the civil section, for example, that may not have existed in your issue estoppel example I gave you, then you may go to a motion for summary judgment. Unfortunately, though, even that area of the law is in difficulty. I'm sure most of you have heard about by now the famous Kilpatrick case, the 30-month notice period in question. This was a case that a motion for summary judgment was brought, principally about notice. The Court of Appeal in this decision held that it's not the appropriate use of Rule 20 to determine a proper notice period in an action for wrongful dismissal. Mr. Justice Wilkes had granted the judgment, but Mr. Justice Borens in the Court of Appeal wrote, and you have the quotation in the paper about, "I'm not unsympathetic of the desire of counsel to resolve the notice issue without the need for delay or the expense of a trial," which George's comments just spoke to, for example. Unfortunately, this requires the court to resolve factual issues. Rule 20 is not the appropriate vehicle to do this opportunity. The reasonableness of notice in the context of a wrongful dismissal action involves a finding of fact, which inherently by that statement means a trial where evidence is given, rather than simply pleadings that avoid that discussion. The finding of fact based on the circumstances of each case. This is necessary and they go back to the case of Burdell, which began this whole business back in 1960. I understand from a conversation in our office, and Mr. Justice Gans has passed along the latest judicial opinion that, in fact, there are a couple of key cases coming out, or have come out, which are supposed to give hope to summary judgment motions. Now, as counsel to plaintiff, I don't have the luxury of relying on hope, because as George has pointed out, your clients are counting on you to give them the best advice possible, and they're spending a good deal of money to follow your advice. And I just don't think that hope is going to bring my clients the satisfaction they might need. So I went back and I did a little digging around, and I came up with an article out of the Canadian Advocates Quarterly. And there's a case that I just want to add in here at this point, because I think it probably answers what I believe summary judgment, the state of that law is currently. The case is spelled Aguonie, and the citation is 1998, 38 OR 3rd, 161. Mr. Justice Borens is also the writer of the decision for the Ontario Court of Appeal. I'm not going to go through the little case with you. I just want to read, he sets out the same test. Is there a genuine issue, which is at trial? It's safe to say that genuine does not mean spurious, or the words for trial assist in showing the meaning of the term. So there's this big, long academic discussion about, well, what's a genuine issue for trial, and what are the nuances of that? But he finishes up with the statement, and I think this is what captures my belief of what I advise my clients to do if they contemplated such a motion. It must be clear to the motions judge, where the motion is brought by the defendant, as in this appeal, that it is proper to deprive the plaintiffs of a right for trial. Now, I can safely assume that depriving the plaintiffs of a right for trial is something any court would be very reluctant to do. I think those words are like bells ringing on high. Summary judgment, valuable as it is for striking through sham claims, that becomes the only thing that Rule 20 seems to apply for. And defenses which stand in the way to a direct approach to the truth of the case was not intended, nor can it in any way deprive a litigant of his right for trial, unless there's a clear demonstration that no genuine issue. So he tips his hat to the old test. But those words, I think, have to leave you with the understanding that most judges in a summary judgment motion, with skilled counsel drafting in a defense or in the motion setting, are going to be very, very reluctant to avoid discoveries, trial, evidence, and the rules of civil procedure applied to all those contexts. So I can only tell you that from my standpoint, I am very, very reluctant to ever recommend such an exercise because, one, I think it's easy for the other side to find an opportunity to punch a hole in what you're doing, and then for all the costs that you spent on that exercise are thrown away. And two, I don't know a lot of judges who really want to make such a ruling and delete this sacrosanct idea of genuine issues which should be vetted at a trial, which I think they're trying to say is the entire point of the legal system. So I know there are people who would not agree with me here that summary judgment's a wonderful thing. I know that 3 to 5 years ago it was very, very in vogue on notice periods. But I can tell you, having read those comments and the decision in Kirkpatrick, I, for one, would be very, very reluctant to recommend such a step unless I at least caution my client of the chance of losing such a motion.
I want to speak next to certain due process issues. And the reason why I think this is important for plaintiff's counsel is because it's an exercise you need to go through right at the outset in terms of assessing whether there are due process issues and what impact those issues have on the ultimate value of the plaintiff's claim. And in this regard, these due process issues fall at least into 3 categories. One is the obligation to investigate by the employer. Secondly, the obligation to specify reasons. And thirdly, the obligation to provide an opportunity for explanation. Now, we all know that the employer bears the onus of proving just cause, and that standard, the standard of proof that's required does vary depending on the severity of the allegations made against the employee. Whether or not there's an obligation on the employer to conduct an investigation also depends, I think, on the severity of those allegations as well. For example, if the employer is alleging criminal actions such as theft, I think there is an obligation on an employer to conduct such an investigation before reaching its conclusion. The Francis and CIBC case is an example in this area. In that case, there was a 12-year employee who was alleged to have participated in an illegal pyramid scheme. The employee was suspended pending investigation, and ultimately, when the investigation was concluded, the employee was terminated. The trial judge in that case noted that in some circumstances, an employer may be obligated to conduct a full investigation before reaching conclusions that are devastating to an employee's reputation. Now, pardon me, this kind of judicial pronouncement really is just shows us the reasoning behind it, what I think is an emerging requirement that the courts want to be completely satisfied that the employer has acted reasonably and in good faith in dismissing an employee. And this also ties in very closely to the Wallace case that I'm sure you've already heard lots about at this conference. The question of whether or not to conduct an investigation is also closely linked to whether or not there's an obligation to provide an opportunity to an employee to explain his or her actions in the circumstances of whatever's transpired. And once again, the Francis case speaks to that, where the trial judge said the law is quite clear that an employer cannot blithely make serious allegations against an employee amounting to fraud or moral turpitude without giving the employee an opportunity to answer those allegations. And I guess this does all tie into Wallace and the requirement from the Supreme Court of Canada that employers in terminating employees must be candid, reasonable, honest, and forthright. And if you interpret those words at their broadest, at their widest, I think we're going to see more case law developing where employers are not only going to be held to an obligation to investigate, they're going to be held to an obligation to allow the employee to respond, and they may ultimately be held to an obligation to provide proper reasons for dismissal. Now, I see our time is quickly diminishing here. I'm going to ask Chris to briefly mention the Sylvester case, and what we'd also like to do is give you some practical considerations and take some questions as well. Chris, can you deal with that for us?
Sylvester is the discussion about an issue that had been seemingly resolved a long time ago. It is the question of whether you can in fact receive notice or severance and also simultaneously or apart from, but in consecutive with, collect disability benefits. Just to refresh you, the old case that was law for, well, it was probably 15 years was McKay versus Camco. And that established the principle that notice is, in essence, job search money. And disability money is something entirely separate. The concept being then if you got sick, you would suspend or put in the freezer your notice funds. You would work through your disability claim. When you recovered your health, the notice would begin again and you could pick up the payments or commence the payments and look for a job. Well, that was, of course, thrown out the window by the Supreme Court of Canada in Sylvester. The court there looked at the same concept again, and they found that the question of disability, they used the analysis that they looked into the intention of an employment contract, and they found in Sylvester that because the employer provided the benefits, paid for the benefits, there was contractually then no obligation or right for the employee to what they called double dip or double recover. The interesting edict that came out of that case, which I found rather unusual from Mr. Justice Major, it was a motor vehicle analysis he used, and basically that case stands for the idea, which I don't understand, that money is money. So that put the whole case law and the issue of disability benefit coverage and notice periods into disarray. There have been discussions since, and there have been a distinguishing feature which has occurred. The law basically became, from Sylvester and the following cases, that if the employer paid for the benefit, that's part of the contract, and they would call that a double recovery. So if you got LTD for 12 months and you got 12 months of notice, you just got 12 months because money is money. However, the distinguishing feature would be that if the employee self-contributed to a disability coverage plan, that's a different form of contract, and that would at least allow the old McKay versus Comco concept to be brought into play. There are some cases that have come up since which are trying to distinguish Sylvester. I probably would have to say quite rightly that amongst people in the plaintiff side of the bar that Sylvester has not been warmly greeted with joy and bliss. And I'm not sure to this day if I still even understand how that decision was arrived at, but that's the one we got. My expectation, and I think other people at the bar would like to believe, that in time, 5 years from now or 10, let's all hope and pray that Sylvester just sort of fades away into nothing land, or something comes back to, shall we say, put some balance into the equation. But as it stands now, that's the law of the land, and that is a very important feature when you meet your client, because you're always advising your clients to have a medical right away to see if they have any disabilities when you first start working with them on plaintiff side, for example. And if they have such a disability or go on workers' comp, you have to have the discussion right away that, for example, according to Sylvester's logic, if you get workers' comp for 12 months, you've just eaten through your notice period as well.
That's a Court of Appeal decision in Dowling.
Yes, and I don't understand to this day how the concept that job search money becomes disability money, it's all just money, is beyond me, but that's the law as it stands right now.
Just a good argument in Dowling, Chris.
Let me take you then, if I may, we're running out of time here. Let me take you, if I may, to what was handed out as you were coming in, the David Letterman Top 10 Commandments for building the successful plaintiff's case, if I can take you to that. First of all, I think you need to review very carefully all the terms and conditions of employment, and in particular, any written or verbal employment agreement. Courts have emphasized in countless cases the individual nature of each employment contract. And because of that emphasis in countless cases, you've got to be very careful to delineate those specific terms and conditions for that particular employment relationship, because that's what's under scrutiny at the end of the day. Secondly, review thoroughly all of the circumstances for the dismissal, particularly the reasons given by the employer. This is often an area that presents a lot of grist for the mill for plaintiff's counsel. And that's simply because if you dig around hard enough, you can often find that there isn't a consistent position on what the reasons are for dismissal. And there's a large number of places you can look for those reasons. You can look to the dismissal letter, you can look to the contents of the dismissal interview, you can look to a letter of reference, you can look to announcements by the employer, whether it's internal, external, to employees, to suppliers, to customers. You can look to internal emails, postings on the bulletin board, mass voicemails. Looking to discussion with potential witnesses, particularly with witnesses who were apprised of the plaintiff's termination before the plaintiff was. Look to the minutes of executive or management committee meetings or board of directors meetings where the termination issue may have been discussed. Look to the record of employment. And look to situations where there may be statutory requirements relating to termination. For example, I believe that employers who engage stockbrokers have to file a notice with the Ontario Securities Commission anytime they let a stockbroker go with respect to what the reason was for dismissal. So take a look at all of these sources as plaintiff's counsel. You're likely to find some contradiction somewhere along the way. Thirdly, prepare an exhaustive list of all elements of the plaintiff's compensation, pension, and benefits package. Can't emphasize that enough. Plaintiffs are less than impressed if you don't go after everything that you possibly can, or at least set it up as a trade-off for what's more important. 4, promote face-to-face settlement meetings or ADR, particularly mediation, and aggressive use of Rule 49 offers. My experience generally is if you can get the parties together, whether it's in a face-to-face parties-only meeting or through mediation, your odds are pretty high that you're going to be able to get the matter resolved. 5, maintain good communication with the plaintiff throughout. I can't emphasize that enough on the plaintiff side. It starts with the first phone call. If you don't get back to the plaintiff within a matter of hours, that plaintiff's gone elsewhere. Their life is upside down. They need help right away. And that has to be a follow-through right from day one with the plaintiff. 6, pleading your case very carefully and also looking to what the defense pleads and whether or not there's sufficient particulars relating to cause. You need to nail that down at an early stage, as early as possible. Be creative and push the envelope. Somewhere along the line, somebody claimed damages for mental distress, and then that became the norm. You've got to think through what makes sense in your particular situation and not be afraid to try and develop the common law. 8, make sure that you know all of the case law from the Supreme Court of Canada. And believe it or not, before Wallace, there were other Supreme Court of Canada cases dealing with employment matters. And in that regard, our High Court has made many significant pronouncements with respect to employment. They've said, for example, that the law governing the termination of employment significantly affects the economic and psychological welfare of employees. They've said that the protection of employees as a vulnerable group in society is an objective with a high degree of importance attached to it. There are lots of pronouncements by the Supreme Court of Canada with respect to how important employment relationships are to individuals, and plaintiffs' counsel need to look to those pronouncements in each and every case that they do. 9, carefully review the Wallace case and keep tabs on the development of case law with respect to that case. very important because that is obviously a watershed case, and you need to know what are judges doing relative to talking about unfair treatment of employees and what that should garner by way of damages at the end of the day. And finally, stay abreast of current trends and pronouncements relative to notice periods more generally. I can't tell you, I'm sure lots of you have been involved in litigation where the litigation becomes nightmarish for everyone concerned because plaintiff's counsel thinks the case is worth 24 months and defendant's counsel thinks it's worth 3 months when it actually is worth 3 months. And if you are plaintiff's counsel and you don't have a good handle on notice periods, it's going to be a disaster for all concerned. So those are the top 10 commandments we leave with you. We're happy to take questions at this point and deal with whatever concerns you may have.
Just the last thing to add is we put at the back a 15-point checklist of if you are plaintiff's counsel, I can guarantee you at least 9 of those 15 better come up in your first meeting. So you may find those helpful. They've probably canvassed every issue that we can think of that any client may bring to your table, so those may be helpful as well.
No one's mentioned the relationship between termination pay and severance pay under the Employment Standards Act. What's the current wisdom of the bench on whether pile one on top of the other?
Sorry, the question is termination pay and severance pay under the Employment Standards Act and whether you pile one on top of the other? I'm not clear on the question.
Well, the only thing is obviously whatever's paid under the Employment Standards Act is a credit towards any notice provisions in a civil trial. And also that brings on the issue that for those people who went to employment standards to make those claims, they're not going to be having a civil trial, as you know, under the bill that Mike Harris passed.
What I was referring to was the maximum of the termination fee is 8 weeks, while severance pay, if the employee qualifies for
50 employees or more, and a $2.5 million.
maximum of 26 weeks. The question is, when you've got a 30-year man or woman, can you claim 34 weeks as statutory pay?
The question is, if you've got a 30-year employee who in theory is eligible for 8 weeks termination pay and 26 weeks severance pay, can you in fact claim both? The answer is clearly yes. With that 30-year employee in that example, the entitlement under the statute is 34 weeks. Yeah, there's no doubt of that. Question?
In the absence of questions, let's take our break now. We encourage everyone, we know it's the afternoon of the second day, but Barry and I have saved the highlight for last. We've compiled the best, most leading edge, most interesting questions we can after a little bit of informal polling of people to see what does the employment bar really want to know the answers to, and we're going to put them all to the judges. So please stay to the judges panel because you'll find it pretty fascinating. And also, would you mind after the break, to the extent you can, for the purpose of that, in any event coming up to the front, if you wouldn't mind, you can do what you want, but we'd appreciate you moving more to the front for the judges panel. Marsha Lindsay's claim to fame, in addition to being on various radio and television talk shows and odd time helping with my columns and doing a bit of teaching and doing a lot of lecturing and being my main junior in the labor law side of my practice, is that she made the crazy error of judgment in letting McCarthy's know she wasn't interested in going back there after she articled, and she'd rather work much harder and be treated much worse by me when I was out on my own.
Well, with that introduction, George Vassos, in his speech on the successful plaintiff case, asked you to watch, as plaintiff counsel, what the courts are doing with Wallace. By now, you all know that Wallace is a Supreme Court of Canada decision that says that employers have a duty to act fairly and in good faith towards employees on dismissal. Well, I've been watching what the court has been doing with Wallace because I represent defendants. And let me tell you what the court has been doing with Wallace. In McGreedy versus Saskatchewan Wheat Pool, the court awarded a plaintiff's additional 6 months compensation as a result of the employer's threat to the employee in order to pressure her to take a improvish severance package, withholding her statutory severance obligation, entitlement, issuing a T4 slip that said that she received the severance when she did in fact not receive the severance, thereby causing her problems with Revenue Canada, and having its in-house lawyer threatened her that if she doesn't take the offer, he will make her life miserable. In Simpson versus Consumers Association of Canada, the court awarded the plaintiff in that case an additional 6 months severance for unfounded allegations of sexual harassment and oppressive behavior towards other female employees, and informing outside third parties that those are the reasons for termination. Now, this was a four-year employee who was earning an income of $98,000 as an executive director. The court awarded the person 12 months severance based on 4 years of employment. The employer's bad faith in that case costed an additional $50,000. $50,000 that was unnecessary, that didn't need to be paid if the employer had acted in good faith towards the employee. In Martin versus International Maple Leaf Springs Water Corp., this is a BC decision. Now, these are all cases, recent cases, 1999, 1998. And what's so surprising is that since Wallace, there has been tons of cases on bad faith conduct and employers being severely penalized for the bad faith. In Martin, the plaintiff was awarded 3 months additional severance on top of the 6 month severance that he received because there was an allegation, false allegation of dishonesty, and that the plaintiff had a drinking problem. Again, the president of the company advertised the reason for termination to third parties outside of the company, which harmed the plaintiff's reputation. Also, the employee's belongings were seized and never returned to the employee. In addition to the 3 month severance that the court awarded, they awarded $35,000 for punitive damages. The employee was a 9 month length, the employee had 9 months length of service. And from that 9 month length of service, the employee received over 12 months compensation. That's not based on notice. That's based on the employer's conduct. In Mitchell versus Westburn Supply, Alberta, the plaintiff in that case received an additional 3 months compensation based on unfounded allegations of misconduct. They alleged that the plaintiff had resigned when in fact the plaintiff had been terminated. They alleged that the plaintiff failed to perform his duties, all of which were unsubstantiated at trial. And they also negatively communicated or communicated in a negative way about the employee to their employees. In McNamara versus Alexander, the Ontario Supreme Court of Justice awarded 2 months additional compensation to a plaintiff where the employer alleged cause and withdrew cause on the eve of trial. The employee was terminated because he had requested a medical leave of absence, and the court felt that this was in bad faith to terminate an employee who requested the medical leave. The employee was earning $176,000. Those 2 months cost the employer $30,000. $30,000 that the employer would not have had to pay if it had acted in good faith towards the employee. In Throng versus the British Columbia, the court awarded 2 additional months to a plaintiff who was terminated as a result of a shoddy investigation. And again, false allegations of cause. In Shadow versus Calsa Community School, a recent Ontario 2000 decision, The court awarded punitive damages in the amount of $25,000 to the plaintiff, again, for unfounded allegations of cause, alleging that the employee was abusive towards female employees, and for advising the newspaper of these unfounded allegations. The court felt this damaged the employee's reputation in the Sikh community. In Noseworthy versus Riverdale Pontiac Buick, the Court of Appeal awarded a 4-year office worker earning $28,000 a year was awarded 13 months severance. 4 years of service, 13 months severance. Again, as a result of false allegation of cause, alleging that the person had forged documentation and the employer had threatened criminal proceedings or charges against the employee. What can we learn from these cases? Well, what we can learn from these cases is that a defendant solicitor's role is no longer just to give an employer what the appropriate notice period is when they're terminating an employee, or to advise on whether or not there's cause. We must advise employers of these cases that are coming before the courts and the phenomenal damage awards and punitive damages that are being awarded by the courts, and the reason why these awards are coming forward. As defendant lawyers, we have an obligation to make sure our clients are aware that their conduct can result in unnecessary cost, solicitor's client cost, increased notice period. In some cases, even if the notice period does not increase, the bad faith, whatever notice period is awarded, the higher end, is a result of the bad faith conduct on the part of the employer. So an employer is now facing solicitor client cost, increased notice period on the upper, the higher side, as well as additional extended notice because of bad faith conduct. I think we have an obligation to our clients to train the managers and the supervisors who are terminating what is required to terminate these individuals, how the termination should be carried out, what is required in the case of an allegation of sexual harassment, such as an investigation. These managers and supervisors need to be properly trained on those issues. Carrying out terminations, we all know that terminations should be carried out in private. If it's conducted in a public manner, that's bad faith. That's not acting fairly towards an employee. We've heard from Wallace that an employer has to be honest, has to be candid, and has to be forthright with an employee on the reasons for termination. We have to also educate these employers on what just cause means. It's amazing. I do a lot of seminars for some of our corporate clients, of the firm's corporate clients, on just the issue of just cause. And a lot of these managers that I conduct the seminars for feel that just cause is, if you don't like the employee, or if the employee is in some manner misconducted him or herself, that's just cause. But that's not just cause according to, that's not the legal definition of just cause. So I go through the incompetence, what's required for incompetence, that you have to set the standard of performance that you require. The employee has to be aware of the standard of performance that's required. The employee has to be provided with the proper training and tools in order to carry out that standard of performance. The employee has to be told if his or her performance is not up to that standard, and the employee has to be provided with an opportunity to meet those standards to get with the program, so to speak. So without those things, without establishing that the employee is aware of the standard is reasonable, and that the employee's had sufficient opportunity to improve his or her conduct, there is no cause for incompetence. There is no just cause. And that's what the employers need to know. That's what the supervisors need to know. These are the individuals that are supervising performance, managing conduct in the workplace, and in most cases, terminating employment for what they feel is cause. Managers also have to be taught how to manage conduct in the workplace. I can't tell you the number of times that I have received calls from employers where they indicate that that's it, they're going to terminate an employee, they've had enough of this employee, and they've misconducted themselves in some form or some way, shape, or form. And they indicate to me that this is not the first time that the employee has misconducted. him or herself. And I say, have you given the warnings? Is there anything on the file? Is there a letter of warning on the file? Any verbal documentation in the file as to these verbal warnings? Nothing. Because they have condoned the conduct to the point where they've had enough, and at that point they want to terminate. They need to know that these are issues that they have to deal with. Condonation, mixed messages to employees. On one hand, you're telling the employee that your performance is not up to standard. On the other hand, you're giving them a raise, you're giving them a bonus. What is the employee to think? Employers also have to be taught about conducting proper investigation. I've referred to a case as my guideline when I give these seminars to employers. McIntyre versus Rogers, which is at page 23-2 of the materials. This should be a guideline. This is a court's criticism of an employer's investigation of an allegation against an employee of sexual harassment and just general harassment. And the court had the following criticism for of the employer's conduct throughout the investigation. They conducted only telephone interviews of important witnesses. They didn't meet in person with these individuals and get their statements. They took no witness statements in writing. They did not interview a key witness before terminating this employee. They made no inquiry as to the working relationship between the complainant and the accused, which is very important. They maintained poor record of investigation. They had nothing to show as to what they did do. And they decided in advance of a meeting with the employee what the discipline would be before they had heard the employee's side of the story. And they did not question the credibility of the complainant, notwithstanding there was evidence that this complainant was not credible. Now, this is just a guideline, but I think it's, given that the fact that this court criticized the investigation, this is a guideline I use for employers as to how to conduct investigations. Because you will be penalized if you conduct a shoddy investigation which leads to the termination of an employee. That's bad faith, and that's not dealing fairly with the employee. I also talk to employers about managing communications. They need to know that as well. What is going to be said to third parties? What is going to be said to Human Resources Development Canada when they call and want to find out why this employee was terminated? What's going to be said to employees when they start inquiring as to why the employee was terminated? They need to have a game plan before the termination or shortly thereafter. And that's something that we can assist them in designating an individual in the organization, a couple of people, maybe one, who's going to answer any inquiry about this employee's termination. We don't need a lot of people in the organization talking about the reasons, the various reasons for the termination. We want one person who is going to follow a script. And that's going to prevent, of all those cases I read out to you, there are about 4 of them where bad faith was found because of the employer's communication with third parties and employees, what was said. They may have believed it to be true at the time, that it was sexual harassment or it was drinking problem. But those allegations, if they had dug deeper, they would have found out there was no basis to those allegations. And because they passed that information on to third parties, they had to suffer the consequences at trial. So as I indicated, our role is, my philosophy is that a good defense starts long before we receive a statement of claim, because by then it's too late. We don't know what our clients have done, how the termination has been conducted, what has been said in the process to the employee, whether or not they've already communicated with outside parties, whether or not they've already alleged cause that wasn't there. Okay. So we need to assist our clients in making sure those issues, those conduct that is resulting in bad faith damages are alleviated, are prevented. They're very preventable. Just going to talk a little bit about, I've been told I have 5 minutes. I want to get into the issue of mitigation, because I think that's an area that a lot of employers for defendants do not explore to the full extent. We tend to gear, especially if it's a cause termination, we tend to gear all our efforts into proving cause. But the reality is that it's going to be very difficult to prove cause. We know that. We've seen all the cases out there where, punching out your employer's best client is not cause for termination. It's pretty hard to prove cause.
You can ask Justice Epstein about that decision when she comes.
We're talking about ditch burn.
And Justice Gouge, because he was in the appeal on it.
So we need to focus on, we need a fallback. And the fallback is mitigation, failure to mitigate. That's another way of reducing a defendant's damages. Now, the onus is on employers. The onus is not on an employee to show to the court that he or she has mitigated or has made efforts. The onus is on the defendant to show that the plaintiff has failed to mitigate. And it's not simply a matter of, cross-examining the plaintiff to a great extent as to what efforts were made. Did you look in the paper every day? Did you look on the internet? Did you engage the services of a headhunter and all those things? Because if we do find out, if we are able to show that the plaintiff didn't look in the paper every day, how does that show that if the plaintiff had looked in the paper every day, he or she would have found alternative employment? We need to have our clients looking in the paper every day, picking out advertisements that meet the skills and qualifications of that employee, and keeping track of that. Because if we can show the court, here's an opportunity that the employee should have reasonably pursued and failed to do so, then that person is not mitigating. That person is not living up to his or her obligation to mitigate. We also need to enlist the aid of experts in human resources matters, people who can give us opinions on how long it would take somebody in this particular plaintiff's position to find alternative employment. Expert reports of those kinds are admissible in court. And since we have the obligation, we cannot rely on a cross-examination or an examination at discovery where we ask about newspapers and internet. We need to get a little bit more aggressive. We need to be monitoring those papers and the internet. We need to be calling our competitors to see if there are positions open and that these employees have applied for it. And we need to file expert reports to help a court determine whether or not the employee did make best efforts to find another job. In one particular case where an opinion of a human resources individual was very helpful is Dixon versus Sears, Inc., where we had a 27-year employee with 55 years of age, a sales manager. She was offered 2 weeks, just over 2 weeks at the time of termination for each year of service, which she didn't find to be sufficient, so she sued for wrongful dismissal. At the trial, the defendant offered up an opinion letter from an expert in regards to the plaintiff's ability to find alternative employment, notwithstanding that she was 55 years of age. And the opinion that they got was that her position was the same as somebody at 40 to 45 years of age. She wasn't disadvantaged by being 55, given that experience was required for the positions that she was looking for. Now, the plaintiff got smart in that case because she got her own expert report saying that basically she was disadvantaged and someone in her position. But the court chose to believe the defendant's expert in that case and dismissed the case. She didn't get a dime because the court felt that she could have found, if she had made the effort, she could have found alternative employment within 12 months, given the opinion of this expert who looked at the plaintiff's mitigation efforts, what attempts the plaintiff had made to find alternative employment. So that's another area. Whether, obviously, the longer the notice period anticipated at trial, the more we're going to focus on mitigation. If we're looking at someone who's going to be getting 24 months or 28 months or 30 months, as in Kilpatrick, mitigation is a huge issue at that point. And we need to focus on mitigation and not just leave it, to chance at trial, which I found in going through some of the cases for my presentation today, that some defendant counsel just didn't provide that evidence. And the court says, I can't do anything. There's no evidence to suggest that the employee would have found alternative employment in that period of time, in the notice period. Therefore, we cannot reduce the notice period to reflect a failure to mitigate. Okay. So just one more thing. I'm just saying our role is more, I think, in light of the cases coming out of the Wallace decision, in light of the fact that just cause is so hard to prove, I think our role is guiding our clients through the termination process and helping them out in terms of reducing their damages if we can through mitigation. That's where I think we're going to be more effective than running after some unfounded allegation of cause, or cross-examining a plaintiff to nausea over an issue that's not going to be able to, we're not going to be able to substantiate at trial. Thank you.
The topic that Marsha and I are addressing is building the successful defendant's case, and I really think it's important, both for yourself and for your client, to define what you mean by success. And that sounds self-evident, but if by success in defending wrongful dismissal claims you mean getting them dismissed with costs payable to the employer, you're doomed to have an unsuccessful career, and you're also going to have a lot of dissatisfied clients. From a defense perspective, about the best you can do in terms of achieving success is getting cases resolved at the earliest opportunity and on a fair basis. And there are two principal reasons for that, and I'm sure many of you have experienced this if you've represented defendants. On the day of termination, it's a matter of principle. They're prepared to devote resources to fight any claim, and the executive that's involved is adamant that the company's position be maintained at some extreme position. The second day after the termination, that usually changes, and business people revert to form, which of course is they want to do whatever their business is. They don't want to be involved in litigation. The second reason, and it's sometimes overlooked, but I think it's important, and that is that companies who terminate employees, especially if there's a reorganization, are looking at the employees left behind to carry on the business. And employees who are still remaining with the company will want to see that people who are being terminated are being treated in some sort of reasonable or fair manner. And I'm always struck by the fact that companies will tell me, well, nobody likes Fred or nobody likes Frida, and nobody will care if they're gone. Well, the moment they're gone, a lot of the employees will be agitated, and it'll be Saint Frida and Saint Fred, and they'll be very concerned that the person has been terminated. And in a lot of companies, it is important that there be a perception of fairness. Now, I certainly agree with Marsha that building the defendant's case, in many respects, you've got to start prior to termination. And one area that I think you can really add a lot of value and you can do a lot is in building a case to resist a constructive dismissal claim. Whether I'm representing employees or employers, I always say that constructive dismissal is the one area of employment law where I don't think that judges start out with an automatic sympathy for the employee, because the employee's position is the situation was so bad, I should be able to get paid for not working. And that's not an inherently sympathetic position. With constructive dismissal, if you're concerned that changes may be a constructive dismissal, there are a number of things you can do to build a successful defense. First of all, you've got to document the changes that are being made. There are a lot of constructive dismissal cases where plaintiffs are successful simply on the basis that it was never made clear to them how the changes in the commission policy would be implemented, how the changes in the fringe benefit policy would be implemented. When the company moved geographic locations, it was never made clear what, if any, support would be provided to employees for traveling costs. So you've got to make sure employers document the changes. Another area that I see quite often is companies, depending on what's in vogue, will come in and they'll say, we're reorganizing to flatten the hierarchy, we're reorganizing to create a hierarchy, and every time they do that, they will get quite enthusiastic about, and we're changing all the reporting relationships, and we're changing all the titles, and we're doing all sorts of wonderful things. In many cases, what I tell them is, listen, do whatever you want from a business perspective, but if it really doesn't matter that much from a business perspective, you're a lot better off to let the form follow the function. You know, don't walk into the person and say, you're no longer the vice president of operations, you're the vice president of special projects. Just start assigning them some special projects, and 6 or 9 months later, you can come along and say, you know, your title doesn't really reflect what you're now doing. Why don't we change the title? The other thing you can do to avoid constructive dismissal claims is have some sort of either notice of the change given to employees or some sort of transitional guarantee to employees. Listen, we're implementing a new commission plan, but don't worry, if in the first 12 months your commissions turn out to be less than 90% of what they were in the previous year, then we'll maintain them at that 90% level. So constructive dismissal, you should be able to do a lot to build a case that something is not a constructive dismissal. With respect to just cause, I think that Marsha's covered that quite well. When I started practicing law about 22 years ago, people actually talked about, let's build a case for just cause for dismissal, and I think it's a waste of time 99% of the time, unless what you're dealing with is deliberate, intentional misconduct. But if you're simply dealing with the fact that somebody is not achieving sales quotas, you might as well forget building a case for just cause. When you're dealing with theft and unethical conduct, and I would include in that any sort of breach of conflict of interest policies, any breach of human rights policies, when you're dealing with deliberate misconduct, one bit of advice you've got to give to employers is don't rush in and confront the employee immediately. If you want to build the case, you have to complete your own investigation as to what has gone on prior to confronting the employee. By definition, you only get one chance to have an initial interview with the employee, and you don't want the employee to have an undue opportunity to come up with some sort of a story that fits the facts. And I've certainly seen that happen where an employer will think they've uncovered a fraud or perhaps have uncovered some evidence of it. They confront the employee immediately. The employee comes up with some sort of an explanation, and of course after he or she goes home and makes a few phone calls, that explanation has a lot more credibility than it might have if the investigation had been completed. You always want to interview the employee as part of building the defendant's case. There have been at least a few court cases I've seen in which courts have said, listen, the conduct the employee engaged in fact, fell short of just cause for dismissal. But when the employee was questioned about it, the fact that they either lied about it or were less than completely candid provides just cause for dismissal. So I think interviewing the employee, having a couple of people there, taking detailed notes, maybe even getting a forensic investigator in an appropriate case, is going to help you build the case for just cause for dismissal. You may also get surprised. I've had more than a few employers over the years that tell me, well, why would I bother interviewing them? I've already talked to 3 people and I know exactly what happened. Well, one reason I identified a moment ago, and that is the employee may actually build your case for just cause if the employee is not candid. But secondly, there may be some sort of an explanation that is relevant to just cause that is completely extraneous to anything the employer knows about. And there was a credit union case a few years ago in which a credit union manager had falsified some expense records and had in effect defrauded the credit union of money. Now, on anybody's score, I think that sounds like a pretty good case of just cause. But this was a very long service employee. It turned out the employee was suffering from depression and some other problems, and the court ultimately said that that conduct, while certainly in isolation it might be just cause for dismissal, was so far out of character that it really wasn't reflective of the person's performance. So, you want to give the employee an opportunity either to help himself or herself by providing a cogent explanation or excuse, or you want to provide them with an opportunity to hang themselves by giving information which is simply not accurate. When you're looking at the defendant's case, there are a number of practical considerations which, if you don't bring them to bear, you may be sorry that you didn't. First of all, a reality in defending any employment law claim is that employees have a huge natural advantage. And the natural advantage is the employee, almost by definition, was present for every event that was significant to their case. I mean, they were the one who was there at work. They were at all the meetings. They were the ones who had the conversations with customers. So you've got to say to yourself, are your witnesses ready, willing, and available to testify? One thing that I always do in dealing with terminations is try to avoid senior executives, in particular the chief executive. If they don't need to be involved in the termination, don't let them anywhere near it, because if you get into litigation, you're going to turn them into a necessary witness. They're not going to want to testify, and you're going to have problems. Another question in putting together the defendant's case is, you've got to ask yourself, by pursuing this defense, are you going to disturb any skeletons that your client would rather leave in the closet? The discussion today, I think, indicates just cause is not a particularly precise and objective standard. It depends upon the context. And so you really don't want to be advancing a just cause defense against an employee, perhaps, who has incurred some questionable expenses contrary to a company policy, if in fact that employee is privy to information suggesting that the CEO of the company has similarly engaged in some sort of questionable conduct. And then finally, I think you always have to say in putting together a case, is this going to attract any sort of unwelcome media attention or other attention? Certainly a charitable institution may not want to put forward a just cause defense that somebody, that they've been lax in their financial management and that someone has defrauded them, because the publicity and the consequences of that may outweigh any benefit to putting forward that defense. As I said at the outset, I think success from the defendant's point of view is getting things resolved on reasonable terms, and you've got to do homework prior to the termination, and I think you've also got to respond appropriately to the types of unreasonable letters that you get from people like Barry Kuretzky. And this isn't fair to Barry, but sometimes I think of some of these demand letters as the Oliver Twist School of Advocacy. Please, I want more, but for no particular reason. And in responding to a demand letter, I think there are a number of things you can do from the employer perspective, and really you do them to enhance the appreciation of risk on the part of the plaintiff. And I always respond to these demand letters as if I'm writing the letter to the prospective plaintiff, not to the lawyer. And Barry Fisher this morning talked about his wrongful dismissal database. Well, what I've done a few times in writing back to plaintiff's counsel, I'll say, well, it's really interesting that you want this particular notice period. I did a computer search and looking all across Canada, looking across Ontario from and after 1990, whatever it is, putting in your client's criteria, here's the result. And when the plaintiff looks at my letter, and I think in most cases plaintiff's counsel are going to hand the letter over to their client, they're going to say, you mean there's a wrongful dismissal database and based on the computer I've already got a fair offer? Secondly, I always point out in these letters that if the person wants to litigate, they have to expect that they're going to incur several months of salary in terms of non-recoverable costs. I tend to point out the obligation to mitigate, and that 100 cents of every net dollar they earn in new employment is going to be deducted. I may point out cost consequences if it's appropriate. Another thing that I will do sometimes is I'll point out that their counteroffer has in fact rejected the original offer. I certainly don't do this all the time, but I'm amazed at how many plaintiffs simply are not aware of that fact. I had occasion recently to write back to a lawyer and say, you've rejected our offer, and now you're indicating you've changed your position. I'll talk to my client and see what its position is. And I got back in one case quite a sort of a snippy letter saying, well, at no time did I tell you that we were rejecting your client's termination offer. But of course, by making the counteroffer, that's exactly what they've done. Another tactic, because of the Wallace case, you want to get employment standards amounts paid very quickly. But what you can sometimes do, especially with a relatively long service employee, is simply say, look, we don't seem to be getting anywhere. Here is 18 weeks pay under the Employment Standards Act. We'll revisit this again after 18 weeks and after we see how you're doing on your efforts to mitigate. And by the way, here's relocation counseling that we're providing to you on a without prejudice basis. Please take advantage of it starting immediately. And that can sometimes be helpful. The point has been made, and I think well made, that part of building the successful defendant's case is to minimize the damage award. In most cases, you can provide a terminated employee with a decent reference. I think you should do that. I know that I deal with a number of clients who simply don't want to provide any reference other than name, rank, and serial number. I think that's unfair. I think it's unfortunate. To some extent, this seems to be driven by experiences in the U.S. where companies, either rightly or wrongly, are concerned about the specter of, well, what if we give a reference and then we get sued by the new employer who claims that the reference overstated the employee's qualifications? My response to that is usually to say to my clients, listen, you are being sued, or you will be sued by the person you've just fired. Any dollar you can save in relation to that claim is a real dollar, and it's really a theoretical concern, I think, in most cases about being sued by the new employer for having given an overly generous letter of reference. I mean, obviously, if somebody is stolen from the company, you can't give them a letter of reference saying that they showed unusual initiative. But I think that in most cases where dishonesty is not involved, you can always find something good to say about someone without exposing yourself to any damage. And as I say, I think it's the fair thing to do. When you get to the litigation stage, I see virtually no reason at all why a defendant would want to bring what I would think of as being a typical pleadings motion. What happens on a typical pleadings motion is that if the plaintiff hasn't got it right to start with, then they get the assistance of a very experienced judge or master on the motion who will point out all the deficiencies in the statement of claim and perhaps suggest some ways the deficiencies can be remedied. I think defendants usually lose ground by attacking pleadings. An exception to that, of course, may be if there's a claim that's simply untenable in law and you think you can get the claim dismissed against one or more defendants by doing that. And while defendants are usually thought of perhaps as being not as sensitive to cost concerns, in my experience, companies are also concerned about costs, and I can tell you my experience in a couple of cases I can think of in dealing with pleadings motions, both of which happened to end up successfully from the defense point of view, but one actually went to the Court of Appeal, the other went to the divisional court. So you can spend a whole lot of money vindicating your position on a pleadings motion. So unless it's important, I would tend to steer away from it. In terms of building your case, very often you build a great case and you just can't get the plaintiff or the plaintiff's counsel to listen. Sometimes ADR can work well for that, choosing a good mediator. I will do some mediations, and often if it's a lawyer that I know who's acting for the plaintiff, we will simply agree and we'll go in and chat with the mediator and we'll say, listen, whoever you want to read the riot act to during the mediation, feel free to do so, but we want something to happen at this mediation. So, you know, we can start out with you facilitating the process, but in appropriate cases, I think it's helpful to tell the mediator to actually knock heads together to try to get the case resolved. From the defense point of view, you start out with a whole lot of sympathy on the side of the plaintiff, and if there's one thing I think you try to do during the process is I think you try to shift the equities to the limited extent you can. If you're going to walk through the courtroom door and you're going to have a judge looking over the record as to how the termination's been handled, how the litigation has been handled, I think you want, to the greatest extent you can, the judge to think that the defense has been conducted in a fair and reasonable and fairly expeditious manner. For what that's worth, at the end of the day, employees get a whole lot of sympathy, and that's why I think you have to start with saying the best settlement is an early settlement, and a client who gets an early settlement, even though they may not be enamored by all the aspects of it, will be a happier client that you'll retain for a longer period of time than one who goes through the litigation process to the bitter end. Those are my comments on building a case, and I think we have a few minutes to take some questions if anyone has any questions. Yes, sir.
I've heard various opinions on whether you should compel certain employees to sign an offer at termination, and sometimes coupled with some hardball positions where you can tell them that they will get their ESA entitlement, but nothing more that they would otherwise be entitled to unless they do sign on.
Let me tell you what I think about that, and if anybody else wants to chip in, certainly that would be welcome. I mean, I can recall, as I say, going back 10 or 20 years, people saying, well, that's how we do it. We give them the offer and we ask them to sign off at the termination meeting or soon after. Well, of course, with Wallace, you just can't do that. Then the fallback position with many employers, if you went back 5 years pre-Wallace, was, well, look, if you don't like the offer, here's employment standards, and we'll duke it out. And I think that pre-Wallace, most judges would say that was a prerogative of a defendant. You know, that if you can't settle, as long as you've met your statutory obligations, you're entitled to your day in court. What I do in a lot of cases post-Wallace is say to the plaintiff, look, show me what you've done to mitigate damages, and as long as you're showing me that you're out there working with a relocation counselor, and as long as you undertake to advise me in the event that you receive any offers and commence new employment, then very often the employer is well advised, I think, to implement what the employer thinks is the reasonable settlement. In other words, to pay the person beyond the statutory entitlement as long as you're satisfied they are acting reasonably to mitigate.
And I agree with John on that issue. One of the cases that I read out to you involved that same issue of an employer pressuring an employee to take an offer by saying, if you don't take it, I'm going to make your life miserable. Not only that, I'm going to give it to you in, if you take the offer, I'll give it to you in the most tax advantageous way. If you don't, then we're going to make it difficult for you financially. And that was considered bad faith conduct, resulting in additional severance being awarded to the employee. So I certainly wouldn't recommend that.
Okay. Any other questions? Yes, sir.
Well, there is a thorough investigation made into the vulnerability, say, of criminality. And there is a investigation having the employees brought in. Shouldn't there be a record, some sort of kept what went on during the incident?
Well, absolutely, there should be some sort of a record kept. On occasion, I know some employers will ask the employees permission to tape the interview, And that can work well. I think at a bare minimum, you certainly want to have two people at the interview, one of them taking some very detailed notes. And depending on how the interview goes, there may be an opportunity to either confirm with the employee immediately after the meeting that the notes are fair and accurate, or provide them with a copy, ask them to review them and return them the next day with any comments. But you certainly want to record what happens at that meeting, because really that's part of the evidence you want to adduce at some point.
Especially if the employee is not honest about his or her conduct. That would be additional cause for discharge, not being honest during an investigation.
All right, any other questions?
So I might have, perhaps you should ask the judge this, but just wondering, what standard of proof should be employed in that kind of a meeting?
Well, there are a couple of judges that will be here, and I always find that first of all, I think that if you try to answer that the way you would answer it on a law school exam, you're probably going down the wrong path. I mean, when you read the cases, they talk about, well, even when criminal conduct is alleged, it's on a balance of probability, but there's sort of an enhanced obligation and the evidence has to be more clear. I think I look at it with clients in sort of percentage terms, probability terms, and I just say, if you're going to allege criminal conduct, you better have evidence that comes a lot closer to the criminal standard, a lot closer to 100% proof. And the whole question of whether you report something to the police is a very difficult question, but small fraud cases, the police just don't seem to be interested in them these days. They will not investigate them independently. But I think that if you're going to allege fraud, you better be looking at having proof in practical terms beyond a reasonable doubt.
Well, thank you very much.
Thank you.